good afternoon, everyone. I'm Milton Marquis, and I'm a member, also known as a senior partner at Cozen O'Connor. I'm based in Washington, D.C., and I'm a partner in our State Attorneys General group. Just a shameless plug for our group. We are the largest, we think we're the best group that represents sometimes misunderstood companies before State Attorneys General. And another shameless plug, we have a blog that comes out every week where we summarize events in the State Attorney General community, law enforcement. I had to write it down because I don't remember it. It's stateagreport.com. So that's the end of the plug. So we're going to have a conversation. We have a few minutes to share with you. We thought it'd be much more interesting if we just have kind of a few questions and answers from our esteemed panel. One of the geniuses of our founding fathers, they did a lot of things right, is that they created a system, a federal system, where the states have a lot of sovereignty, a lot of independence, and that was one of the tensions at the founding of our country. How much power is going to be centralized? Well, there was no Washington, D.C. at the time of the founding of our country. If you've been to Hamilton, you know that. So how much power is going to be centralized in our federal government, and how much power are going to remain in the states? And that's a tension and discussion that we're having today. So when it comes to compliance and consumer protection, consumer fraud, securities, antitrust, the states in the Office of the State Attorney General have a great deal of independence for the most part, and there are always some exceptions, but for the most part there is no federal preemption. Maybe in securities there's some. Feds don't completely occupy the field. But certainly when it comes to consumer protection and antitrust, Supreme Court has made it clear that the states have independent authority. So every state is sovereign. The Attorney General in every state, he or she, will be quick to tell you that he or she is also sovereign. They don't, except of course in New Jersey, the governor appoints the Attorney General. But I don't believe the Attorney General of New Jersey, I'm not putting you on the spot, believes that he works for the governor. So every Attorney General is sovereign, every state is sovereign. States have a lot of independent authority. States work together a lot, and the states work with the federal government. And that is true today. That was true when I first started practicing law as a young Assistant Attorney General in the Commonwealth of Massachusetts, and that's true today. So we're going to have a conversation. We're going to leave some time for questions, but state AGs are really at the forefront of enforcement. And if you're a compliance professional, you ought to know who they are, what they do, what are their priorities. And that's what we're going to talk about. Now, we're fortunate that we have representatives today from 3 offices of the Attorney General that are very active. They've historically been active, and these folks are veterans of enforcement. Chris in New York, I think you're the newcomer to your job. So, and these 3 offices are different in structure, not so much necessarily in priorities, but our job, our task today is to demystify attorneys general. We'll do the best we can in the 30 minutes that we have. So I'm going to start off with Paul to kind of talk about, because New Jersey is a little bit different than most AG offices, at least in the consumer protection function. So why don't you tell me how you're structured?
Absolutely, absolutely. So as you mentioned, New Jersey is a bit atypical. It's structured a little bit differently. The Attorney General's office is somewhat larger and encompasses a lot of sections and a lot of divisions that are that may be separate agencies in other states. So the Attorney General's office, for example, encompasses the state police. It encompasses the Division of Criminal Justice and oversees all of the prosecutors throughout the state. It also encompasses the division that I had, the Division of Consumer Affairs. So the Division of Consumer Affairs, while most state AG's offices will have sections within will have divisions or sections that oversee consumer protection, that oversee healthcare fraud and different areas. We have a somewhat larger office. We have 540 people within the Division of Consumer Affairs. Within that division, we're invested with enforcing the Consumer Fraud Act, which is one of the most robust consumer fraud acts in the country. There's also dozens of similar consumer protection statutes in New Jersey, and it seems that every year there is more that we are responsible for enforcing. In addition to the consumer fraud enforcement, our office also, we regulate a large number of businesses that need a license to work in the state. Many of them come through our office. We also regulate all of the professional licensing boards, everything from your doctors and your nurses and your plumbers. We regulate the securities industry for the state. We regulate charities. We regulate weights and measures, and on and on.
Yeah, great. So Chris, you oversee several of, just from shorthand, some of the affirmative litigation bureaus in the New York Attorney General Office.
That's
but if
right.
you could kind of start off when, obviously you have the Attorney General, and you have a lot of lawyers, and you have
A lot of lawyers.
That's not a bad thing, by the way. Lawyers, that's not a bad thing, but go ahead, Chris.
I'm glad you feel that way. So within the Economic Justice Division that I oversee, we have 5 affirmative litigation divisions, including our Investor Protection Division, which oversees enforcement of the Martin Act, which is charged with prohibiting misrepresentations in the sales and offering of securities. That's a broader definition of securities than you have under federal law, and there's actually quite a bit of broad reach within that office. Historically, we've used that provision, that set of provisions, quite aggressively to combat fraud in the investor community. We have our Consumer Protection Bureau, which in addition to overseeing enforcement of our state consumer protection laws, including fraud, unconscionability, and deception, we also oversee enforcement of some federal consumer protection laws, including the unfair, deceptive, and abusive acts and practices provisions within the Dodd-Frank Act. I know that's something near and dear to many of your hearts, those of you in the financial services community. Within my division, we also have the Antitrust Bureau, which oversees enforcement of both the federal antitrust laws and our state analog, the Donnelly Act. And we have a Bureau of Internet and Technology, which handles data and privacy issues and consumer protection issues where there's a particular technological component to whatever matter might be in front of us. And then finally, the Taxpayer Protection Bureau, which deals with our state False Claims Act litigation as well.
Thank you. So Sam, you are a veteran of the Pennsylvania AG's office, so I think you may have the longest tenure in terms of, at least on that side of the stage there, in your particular role. So can you tell us a little bit about the great state of the Commonwealth of Pennsylvania?
Yes. First, I'll preface what I have to say that whatever I say here today is my own opinion. It's not the opinion of the Attorney General or the Attorney General's office.
Same here.
Sometimes I have to say that because I'm very opinionated, and so I am the Assistant Director of General Litigation for the Bureau of Consumer Protection in Pennsylvania for the Pennsylvania Attorney General's office. The Bureau of Consumer Protection falls under the Public Protection Division that has other areas like civil rights, charities. So the Bureau is one part of that. We have 3 offices three main offices across the state where we litigate. It's Philadelphia, Harrisburg, and Pittsburgh. And we are charged with enforcing the unfair trade practices and consumer protection law, which prohibits unfair and deceptive acts or practices. So that's kind of, and what we do is, I kind of try to boil it down to 4 things. We mediate, investigate, litigate, and educate. Educate kind of speaks for itself. We have a website. We give tips on deceptive business practices, what to look out for. Also, when we file a lawsuit, which kind of goes with the litigation, we do press releases informing consumers. We've taken action against this company. You might want to submit a complaint if you have a problem, giving tips about the business practices that we sue. If I had to, and I'm going to get into a little, if I can, what I think is probably most important for the compliance people, you would think that it's investigation or litigation, but you want to avoid getting to that point. You want to, I think what businesses, they shortchange themselves when they don't pay attention to our mediation effort. We have a mediation effort. Consumers submit complaints. I think last year we mediated about, I think it was 40,000 consumer complaints in Pennsylvania. And I think businesses do themselves a real disservice if they don't pay attention to what we're sending them, because consumer complaint, I mean, there's other things that we look at to start an investigation. Media, whistleblowers, we get all kinds of information from all over the place. But we engage us in mediation, and when a consumer sends us a complaint, we send it to the business. Compliance people should be really on top of that, because that's the biggest window that you have into what we're thinking when we start an investigation. And I can't say that enough. You can't imagine how many people come in response to a subpoena, and we say, hey, we think you're doing X, Y, and Z. Oh, we didn't know anything about. Well, I just sent you 500 complaints over the past 6 months. You didn't know what they were complaining about? I mean, you really, if I were in your shoes, I would have like a triage of anything that comes in from a regulator or a law enforcement agency, triage those complaints and see what they're complaining about, and try to be proactive about what you're seeing. Because what we're seeing is what you would be saying, because we're sending it to you.
Yeah, Paul, why don't you pick up on that? I think that's a very good point that we often tell our clients, track, particularly if you're a consumer-facing company, track your complaints, because offices like Pennsylvania, consumer writes in directly. Sometimes they don't write to the company. Sometimes they write directly to the Attorney General's office, and they'll send the complaints in. Ought to set up a system where you can track it, because I think, Chris, you made a very good point. I mean, not Chris.
Sam, yes.
I would agree with that point, though.
Sam, but Chris, I saw Chris nodding. Sam, you made a very good point that that sometimes that can lead to a subpoena, and then that really elevates things within the company. Chris, you go ahead.
Well, I would say,
and then Paul. I'm sorry.
Similarly, at the New York Attorney General's office, and prior to this, when I was at the CFPB, complaints factored heavily into the enforcement actions that we brought. Oftentimes, it's if we have an area of concern, it's the entities where we're receiving the most complaints that we look to first to try to see whether or not that concern has merit, and they're the ones that are going to be on the receiving end of a CID or a subpoena in those circumstances. And so if I were in your shoes, just as Sam said, I'd take those complaints very, very seriously and think about how you can incorporate that into your business practices. The other thing I would say is look at the resolutions that attorneys general and federal regulators are entering into. I know there's oftentimes criticism of, well, you're asking me to look at these resolutions. Aren't you suggesting that's regulation by enforcement? I think it's just common sense that you would look to see where other companies or entities that are engaged in the same practices you're engaged in might have fallen short of their legal obligations, and try to make sure you build that into your compliance structure. I think you'd be, foolish to stick your head in the sand and pretend that the same problems that existed at one of your competitors couldn't have cropped up at your entity as well.
Yeah, Paul.
And I can't stress enough what was said previously about treating complaints seriously. I mean, obviously you want to treat any communication with a regulator seriously. You want to cooperate, you want to be responsive to subpoenas, you want to be responsive to even more informal requests for information, or someone reaching out to let you know that there's a concern. But the thing I want to stress is two things. There's many ways that, as Sam mentioned, that complaints many reasons we may open up a complaint. So we might be reading something in the media, we might be hearing something from another state's attorney general's office, we might be, things may come to us through many different mechanisms, but certainly we take complaints very seriously. People come in, we're constantly looking at what are our top number of complaints, what type of complaints are there, who's complaining, what are the issues, are there issues that we're getting complaints about in one industry, perhaps from one of your competitors, that makes us take a broader look at industry practice. The other thing, though, I want to just stress a little bit before the complaints come into us and before you hear from our office, we're set up a little differently from the other states. We don't necessarily, as a matter of course, reach out to the business first to try to resolve it. If there's a reason if we're getting a number of complaints in, we might work up that case in advance. We might get a lot of information. We're not necessarily going to reach out to the company right away and say, oh, would you mind taking a look at this? At the point where we're reaching out, it might be because we actually already have concerns and have already built up a case. So take those things seriously. But also, even before that, one of the things that we see just as compliance professionals, you want to keep an eye on this, is that by the time someone makes a complaint to us, it's because they've been running into a brick wall at your company. And so many of the times people come to us not because, and certainly people reach out to us as a first course of action, but many times people come to us, they are frustrated, they're fed up, they're not getting answers from the company, they've been trying to resolve something. So make sure the customer service functions that you have are one of the most important compliance functions that you have. You want to make sure that complaints are being resolved, they're being attended to. And also, I mean, just obviously you want to pay attention to and respond to complaints as they come to us. Keep in mind that if we're getting repeated complaints, even though you may have resolved it for one person, take a look globally at the types of complaints that you're getting. How do you resolve those on a global scale? Because yes, we sometimes get businesses that will get 20 complaints about a single business. Each one of those complainants, they're made whole, and so the company thinks that that's fine. But then, that might be enough for us to look at what are the global business practices here of the company and realize there might be 20 people that have made whole, but there's, another 200 people that are out there that are similarly affected.
Right. Just to build on that a little bit, just really looking at what is the root cause of the complaints that you're receiving and making sure you're fixing that root cause as opposed to just fixing the immediate problem in front of you and that immediate complainant. The other thing I was going to add to what you said is if you look beyond just the consumer complaints you're getting, but especially given historically so many of the problems we see are a consequence of bad management incentives and your incentive structure that you set up. Oftentimes you're going to see complaints not funneling necessarily in the first instance from your consumers, but funneling from your sales force on the ground, the folks who are interacting with your consumers who aren't able to meet your performance measures, who aren't able to meet the incentives you set up for folks. That can be a signal that those performance incentives, if they're not able to meet them, there might be people gaming those performance incentives in ways that are going to have adverse consequences for your consumers and maybe in conflict with your legal obligations. And so also being attuned to those internal complaint systems and your workforce complaint systems as also a way for your compliance folks to get a handle on where there might be problems within the organization.
Absolutely.
Sam, did you want to?
I was going to say, just following up on the mediation, I can't stress how important it is to try to get out in front of an issue that may be popping up in these complaints. You would much rather, if you got a subpoena from us, you would much rather be in front of someone like me saying, oh, we saw that 6 months ago, and look, I'll just say, maybe there was a contract provision that wasn't clear and conspicuous, and consumers are not understanding why, the contract renewed when they didn't, So maybe you recognized, oh, well, maybe we'll redo the contract and we'll make it clear and conspicuous. We'll move the automatic renewal to the front, make it bold, make it big, let the consumer, initial it so they understand it. So then when you're in front of us, when I send a subpoena, you can say, we saw that 6 months ago and we redid our contract and we send notice to people, whatever the issue is. It's important to be in front of us and say that you're in front, and let us know that you're in front of the issue. Because a lot of times we'll send a subpoena out, we'll ask questions, but it doesn't mean it's going to go any further than that. I mean, it's possible that it gets closed. For everyone that goes to a legal action, there's other ones that don't progress to a legal action. A subpoena gets issued so that we can find out why is this happening, and you should take that as an opportunity to explain to us why certain things are happening. It's not an attempt by the Attorney General to run your businesses. I mean, you don't want government running your business. But government is good at enforcing the law, and that's what we do. And we hone in on issues, and we'll make sure that those things are being taken care of. And if they're not, we're going to enter into an agreement, or we're going to go on to the next step, which is litigation. And we will sue if we don't believe consumers are being treated fairly.
So as the senior officials in your offices, you mentioned auto renew, and I know that's a very important issue for certain AG offices. If you could just pick one or two kind of priorities in your offices for the audience. So why don't I start with Chris?
Sure. If I were to pick two, I'd say small business lending, and generally making clear that the consumer protections, particularly at the state level, that apply to consumer lending, there's no reason to believe that those should not be extended and afforded to folks in the small business community. And the thing that's important to recognize here is sometimes we indulge this fiction that because you're a small business, you're somehow more sophisticated and therefore not entitled to or shouldn't be given the same level of protection as a consumer. But when you're talking about a mom and pop shop and a sole proprietorship and things of that nature, that fiction really evaporates pretty quickly when you start digging into the underlying premise. And so a big priority for us at the New York Attorney General's office is looking at entities that are offering small business loans to small businesses, particularly those that are truly, truly small businesses, and the terms of that lending, the way in which those loan agreements or financing agreements are marketed, the interest rates and whether they violate the state usury laws. And second area that we're particularly focused in as the housing market has done quite well for an extended period of time. There are good federal protections in place. There's an open question about what's happening to folks, though, at the sort of the cusp of home ownership with those smaller dollar properties out there. Particularly, you're looking at manufactured housing, folks who are looking at contracts for deeds, places where the terms of the financing product are not typical of your ordinary mortgage product. They're not necessarily always covered with the same protections that your typical mortgage might be. As the mortgage market gets to its peak, you're going to find more and more lenders trying to dig deeper and deeper and deeper into that marketplace to find that next marginal consumer to get into a home. That's how we got ourselves in trouble the last time, and we're going to be looking carefully at the edges of the marketplace to see where there might be opportunities to take advantage of consumers and illegality.
Yeah, and you read it in the program. Chris is also, prior to his position in the AG's office, I think your last job at the CFPB was Chief of Staff. So you were senior person in the CFPB.
I was overseeing supervision and enforcement. I had been Chief of Staff.
Yeah, okay, yes.
So I'm familiar with the folks there who are very great folks, despite a lot of what you read in the media. There's changes in administration are normal, and there are a lot of great folks doing great work there.
So, Paul, one or two priorities from great state of New Jersey?
Well, we are very focused on issues that affect the most vulnerable populations. So we are, I think, to echo some of what Chris was saying, I mean, we're very concerned about predatory lending writ large, which to us can be seen in areas of, certainly we're also concerned about small business lending that might be predatory. We're very concerned about other types of small loans, alternative loans. We're very concerned about lending that in spaces in which they might be connected to student lending and student loans, for example, particularly when they're taking advantage of the most vulnerable populations. We've been focused on, we recently had an action against an auto sales and auto lender that was churning vehicles. These to us, we see them all very connected and very, very similarly. Mm-hmm. You mentioned the CFPB, acknowledging how great the staff is there. We work with them very often. They are, the people there have been great partners. We are concerned about a lack of enforcement or a stepping back of enforcement in the past couple of years. And certainly when I came on board, the New Jersey Governor, Phil Murphy, and New Jersey Attorney General, Gilbert Grewal, both expressed an interest in our office coming in and looking at a lot of the consumer finance issues, making sure that issues that we had previously sent to the CFPB to making sure that they were appropriately being addressed to the extent that federal agencies and our federal partners were not willing to take those on. We certainly still work with them. They're great partners, but we have seen instances in which they've been interested perhaps in, they've not been moving forward with planned regulations, rolling them back, or some enforcement actions have not been moving forward. So we are very interested in taking those matters on. A part of what that means for us as well is, Nick, you mentioned before, or Sam, sorry, you mentioned before working with, paying attention to those consumer complaints. I think part of what we're doing is looking not just at those consumer complaints, which is bread and butter. It's very important. It's how we get a sense of keeping our ear to the ground. But part of what it means to us to take that on that role in a bigger picture is to look at what some of the larger issues that might be happening in the state, some of the issues that might be more systemic, and seeing how we can dedicate our resources to protect the most vulnerable people in the state.
Thank you. So Sam, I know that your office, under your current Attorney General, established a financial services unit within your Consumer Protection Division. So not trying to lead the witness, but what are the priorities at the Pennsylvania Attorney General's office?
Well, I think that has grown into, when Attorney General Shapiro got elected in 2016, he came in and immediately established a kind of CFPB within the Bureau of Consumer Protection. And it's headed by Nick Smith, who's a former CFPB compliance attorney, or I guess he was
an enforcement attorney.
An enforcement attorney, yeah, he was an enforcement attorney. So now he's heading up that unit. Before he came in, we didn't do a lot of that stuff. It was kind of on the back burner, but Attorney General Shapiro came in, and that was really a priority for him. He sees a lot of lending as a possible way to do mischief, and a lot of people get hurt by doing it. A lot of these transactions might be complicated. Consumers might get hurt by it. Some of the actions that under that, we've been engaged in a payday lending case, auto title lending case, mortgage cases. So lease to own properties is a new kind of problem where companies sell these houses, but they're actually leasing them, and then consumers get these houses that you can't even live in, and they're on the hook for these leases, and it's just a nightmare. So that's a new kind of scam that's going on that we're worried about. But besides the consumer financial protection, he's also worried about quality of life type stuff. Mm-hmm. So, the little old lady who pays a contractor $30,000 to fix her house and they disappear. That's a lot of people can sink their life savings into fixing their house up, and what's the recourse? So we're aggressively attacking quality of life type stuff too. So they fall into those types of categories. So I would say quality of life and
Sure.
consumer
Appreciate
financial
that.
protection. Yeah.
So Chris, did you?
One thing I did want to, because we do have folks here who are, you work for lenders, you work for companies that are trying to provide access to credit, and I want to don't paint a picture of state AGs that's not recognizing the important role that the lending community plays, and the fact that we want access to credit in the marketplace for the greatest number of folks who can take on that credit in a responsible way and an affordable way. And what we're looking at here is to ensure that's being done in a way that's compliant with the law, that consumers understand what they're getting themselves into, and that it's consistent with the capacity of those consumers to actually take on those obligations. But we can paint a picture of the things we're concerned about, but also important to recognize that many of you as compliance folks are out there trying to figure out how to do this in a sustainable way, and that's an important thing to do.
So we've talked about your individual states' priorities, and at the beginning of this session, I mentioned that states do work together a lot. And a big part of what we do in our practice is that we represent companies that are faced with multi-states. And I like to tell people, showing my age, a long time ago when I was first practicing law as in Boston in the AG's office, this was before the internet. My kids were like, there was something before the internet. Yes, there was before the internet. And we set up this kind of closed loop communication system where we could do things that no one had ever done before, like working on a Word perfect document, and actually email it to each other and work collaboratively. And that was one of the first steps towards kind of what I call the modern era of state AG enforcement, where states collectively pool resources and work together as a multi-state, kind of sometimes in parallel with the federal government, sometimes alone, so that you can have, now CFPB, you can have state CFPBs working together, or the Federal Trade Commission or the Antitrust Division. And I think that for a lot of corporate America, it's kind of a mystery to how does something become a multi-state? So I'm going to ask Paul, why don't you demystify for this crowd, how does something that may start off with maybe a consumer complaint in Pennsylvania and somehow or another it becomes a multi-state investigation, how do you all work together? I mean, do you have like a task force? This is a leading question, I know the answer. You guys get on the phone together, or you Skype? I mean, how does something become a multi-state? How do you all work together? Because you're all a sovereign, so how do you work together?
Well, I think there are lots of different mechanisms and lots of different types of multi-state investigations or cases that might be brought. But generally, I mean, we, first of all, us in the Attorney General's community, we know each other. We have worked, many of us have worked together for many years. I am fairly new, Chris fairly new, but you know, Sam has been around for some time. It is a tight community. People have worked with each other for many years. So there are times when you might just see something that's amiss, and you might pick up the phone and call someone in another office. We might do that, for example, where the company that is, we're getting consumer complaints in New Jersey, but the company might be based in another state. Or we might see this as something where, I mentioned before, we're interested in widespread industry practices that might be causing significant financial harm. So we might reach out to designated groups where we know that there are certain states that are more interested in certain types of cases, right. Or we might know that this industry exists more in certain states. So we might call up and say, hey, have you seen this before? Is this something that you are seeing? Has anybody before worked on this type of case? There are also, through the National Association of Attorney Generals, there is a more formal process in which we may reach out to them and they can reach out to other states. And certainly there are enforcement actions in which the National Association of Attorney Generals will work together. They will coordinate the functions. Right. They will make sure that they're, one of the rules of that organization is that there's a Republican and a Democrat right. Attorney General. To us, does not matter as much because, as you mentioned, we're not an elected Attorney General, but we want to make sure that the Attorney Generals, the offices work together to the extent that we're seeing something that might be in another state. As a courtesy, we'll reach out. But it's also very, very helpful to hear from other states the types of practices that they're seeing, what types of claims that they've made or they've made in the past. And it's an opportunity for us to also get the attention of industry or certain actors to be able to say, listen, this is not just one consumer complaint that has come in, but it might be hundreds and it might be spread out over 25 states. We're all concerned about this. You need to take this seriously.
And it's pretty bipartisan as well, like you say, that at the staff level, very apolitical. That's right. And even at the Attorney General level, there's a common purpose when it comes to protecting consumers. So it's certainly within the state Attorney General community, you're not going to find a lot of daylight between Republican and Democratic Attorneys General. Sam?
Yeah, you might find out that there's other states, maybe through a subpoena, you have them in, there are other states looking at what you're doing, and there might be multiple other states that you didn't know about. You might find out that way. And sometimes the company may actually invite a multi-state because they want global peace, and they don't want to fight on 50 different fronts. So they might say, hey, there's other states looking at this, why don't we, get to one resolution?
Well, I think
that does happen.
That's a very important point that, I think when I first started practicing in this area, clients would be afraid that there's a multi-state. I said, it's really in your interest to have a coordinated, very professionally run investigation, with some leadership and direction, in the leadership of the multi-state, and as you said, Sam, global peace. So Chris?
I don't know that I have much to add to that. And I mean, at the end of the day, each of us has a duty and an obligation to ensure that we're doing the best for the people of our state. And so one of the factors that will go into it is whether or not we believe any individual multi-state can adequately vindicate the rights and the expectations of the folks of our states.
Well, we have ended just in time. We have 9 seconds left on this panel. And we want to keep everybody on track, and we hope that we try to anticipate questions from the audience, but we had a lot of questions here, but I saw a hand up. Yes?
How do you guys feel about the California Privacy Act when it looked back in 2020? Are your states going to do anything similar to GDPR
I'm glad that I'm a moderator, because our clients really have a lot of heartburn over this, but go ahead. I'm not speaking for any client of Cozen O'Connor, what I just said.
So I won't speak to California's law in particular, but I do think data and privacy is one of the most important set of issues that we all have to collectively deal with from a public policy and a regulatory standpoint. In New York, there's a law called the New York SHIELD Act, which is currently before the legislature and has some momentum. Wouldn't do quite what the California law would do, but would enhance some of the protections that would exist in New York around data security and data privacy. And the Attorney General has been a public advocate for that law passing.
Yeah.
In New Jersey, there was a law that just passed to enhance some cybersecurity protections. I will say that there are others that are before the legislature now. The Attorney General has set up a cyber unit within the Attorney General's office. We are very concerned about issues about privacy, of making sure that adequate disclosures are made, making sure that companies are taking care of using appropriate measures to manage and maintain the security of their data, and reacting appropriately if that data is in any way impinged on. One other thing that I just wanted to say as well, I think it's very important in this audience to echo and to acknowledge what Chris has said about, I mentioned that I was concerned about vulnerable populations. There are many companies that are doing very important work and providing important services to those vulnerable populations. We see industry as partners. I do a lot of meetings with industry groups. We do a lot of meetings with compliance professionals. You are the ones that are helping make sure that companies are looking appropriately at how to manage risk within the business, at how to protect your clients, how to protect your companies, but also how to protect the people who do business with those companies. As a state, New Jersey, and I'm sure the same goes for your states, we care a lot about and believe in technology and innovation. We're not trying to impinge on that in any way. We are trying to make sure that as you move forward, be it an existing business or you're carving out and trailblazing and creating a new service that has never existed before, that you're doing so in compliance with the law. If you have questions, we are here to help. We're here to talk to you. We want to know about things that you're thinking, things that you might be concerned about, and we want to also, some of the best cases that come to us come from business and come from industry who say, I don't like what this person's doing, I think it's a bad idea. But I just really want to emphasize that we want to be able to work with industry.
Okay, I think we have time for one more question, ma'am.
This is kind of a weighted question. Now that we're seeing the federal regulators being more supportive of the bank partnerships with fintechs, and this is probably a question more so for Chris and also for you, where do you see your states coming out in terms of being supportive of those types of partnerships, states' rights versus federal rights, the valid when made doctrine, Madden v. Midland, and all of that? Do you think that we're moving forward towards progress to see some sort of cohesiveness between federal law and state law, and the states' rights versus federal rights?
So I think the question has two parts to it. One is just sort of a evolution of the industry and business practices. My sort of hypothesis is that the funding structure is such that many fintech companies will find it advantageous as they scale to partner with banks. It's just the nature of the way the regulatory system is structured, and the funding advantages that banks have are special. To the extent that those partnerships are entered into or seek to evade state laws, or to the extent that preemption is used as more of a shield than it has historically been, that would be problematic from New York's perspective, and I assume for other partners as well. We believe that there's an important role for state consumer protections to play. We believe that federal law should be a floor, not a ceiling for those protections, and we would see it as problematic that any sort of erosion of that structure. But in terms of whether a business model works from a financial standpoint, or whether it advances opportunities to provide access to credit or other financial services to consumers, we're all for doing that, provided it doesn't lead to a race to the bottom on the consumer protection side.
Okay, well, we have the red light flashing. I want to thank our excellent panelists. So thank you very much for your insight.